this too often, but when we do talk, we talk with some sense. Nusrat, please join us. So we have a very interesting lineup of speakers. Hi, I'm Shweta Bharti. I'm the senior partner at Hammurabi and Solomon, and I'll be moderating the session today. We have with us Mr. Let's start in this order. So we have Mr. Naresh Thacker. He is the senior partner at Economic Law Practice. We have Mr. Badrinath Durvasula. He is the ex-managing director and legal advisor at SR Group, and he has been former head legal Larsen & Toubro, Adani Group, Reliance, and HCC Mumbai. We have next Ms. Neeti Sachdeva. She is the Secretary General and Registrar at MCIA, and she does not need any introduction at all. Next to Neeti is Mr. Nusrat Hassan. He's the managing partner at Denton's Link Legal Mumbai. And next to Nusrat is Mr. Ajay, Bhargava, senior partner, Khaitan & Co. So as you can see, none of the speakers actually need an introduction, and therefore I think I'll start with the topic immediately. So it says third-party funding in international arbitration trends and challenges. Now, third-party funding, so far as India is concerned, has been, a matter of discussion since 1876. While I was doing my research, I realized that in 1876, the Privy Council had given an observation with respect to third-party funding being permissible in India. So, irrespective of whatever we have been thinking about with, with respect to third-party funding being restricted as a champerty, as in maintenance, is all something probably which does not have a backup in terms of law. Legally in India, there are no statutes which really restrict the third-party funding. So what really is the reason why it has not picked up is something that we are going to discuss today. And how are we going to increase the third-party funding in that sense in the international commercial arbitration? So if we look at, as I told you, the history does not restrict, the statutes does not restrict the third-party funding. There are different judgments which have been passed by different courts, including the Supreme Court of India. And that is something which is very interesting that I observed, that even in the case of Bar Council of India versus A.K. Balaji, in 2015, the Supreme Court has said that there appears to be no restriction on third parties, that is non-lawyers, funding the litigation and getting repaid after the outcome of the litigation, along with specifically excluding lawyers from adopting the role of funders. So while it does exclude the lawyers from the role of being a funder, there's no such restriction as such. So with that kind of observation by the Supreme Court, making the law of the land, it is interesting that why still the third-party funding has not taken off as a concept. Now, there was one instance which was observed by the Honorable Delhi High Court, and I'm sure the speakers are going to talk about it, is the case of Tomorrow Sales judgment, which was passed in 2023, in May of 2023 for that matter. And there, in fact, the court had, given a lot of emphasis on third-party funding being essential to ensure access to justice. So with that background and, coming straight to Mr. Badrinath Durvasula, because he was as the General Counsel of HCC, in fact, he has been the pioneer in the sense with respect to third-party funding, where his company had then entered into an agreement with a consortium of investors, which was led by BlackRock, to monetize an identified pool of arbitrational awards and claims for a consideration of 750 crores, for which purpose a special purpose vehicle had been created. Similar arrangements we have seen also in the cases of Patel Engineering and Era Infra Engineering. So coming to you, Badriji, and I would want to understand from you, what are the expectations from the industry in the context of time versus cost versus opportunity? And what are the typical kind of disputes which the industries would like to offload, and in the context of third-party funding?
Thank you, Ms. Shweta, for the wonderful introduction. I think I'm singularly fortunate enough to be working with HCC, Hindustan Construction Corporation, at that point of time, and when the deal has happened. But today, disclaimer is that whatever I'm going to talk, it's what is there in the public domain, and what has happened behind is something I'm not supposed to talk. But nonetheless, I'll give you the flavor about what has happened. Today, if you look at any kind of a construction kind of a contracting, be it a Larsen & Toubro, be it a kind of a HCC, those who are dealing with the PSUs, NHPC, NHA, NTPC, etc., there are a lot of government contracts which are there. Today, per se, if you talk about it, the major litigants in the country are the PSUs. That's the government of India. So that be the case. Today, the companies who are working on the frontal, they have to bear the brunt, because every matter goes into some kind of a litigation. Every contract translates to at least 4 to 5 litigation aspects of it. So these are the companies. Now today the HCC is the one which is there in the public domain. Another is Patel Engineering is the one which are there in the public domain. there are numerous companies, including that of Larsen and Toubro, who are facing huge number of litigations, and they have to incur a substantial cost, as well as they need to spend their resources on this, and they need to block their balance sheet also. All the three things are now completely kind of a bottleneck for them to handle that. So today, the third-party funding is the one which would facilitate. In fact, if Shwetaji's introduction says about it, there is no bar for the third-party funding, but there is no facilitation also for the third-party funding. I think the rest of the panel will speak about it, how to facilitate. But the point is, if we have a third-party funding, what's going to happen is that we will optimize on our costs. That means the company will not have to deploy its employees to handle the kind of litigation. They would not unnecessarily budget the costs for the kind of legal expenses which are uncertain. And then third most important thing is the timing. Because as you know, that any kind of a little arbitration dispute to anything else, it would take about 0 to at least 5 to 10 years. That's the kind of a span we are looking at it. The company is not sitting here to handle this kind of a disputes. They wanted to offload. So that's where every company's perspective is to avail the third-party funding. That's a kind of an industry demand, I'm saying it. It's an industry demand. Government can do it and it can be facilitated. That's what we look at it as a kind of an opportunity to optimize on our strengths, to earn on the business rather than spend on the litigation part of it. That's what we look at it.
No, thank you so much. Actually, it gives us an industry perspective. And Nusrat, now I am coming to you because what we heard from Badriji and what also the Delhi High Court says that, you know, it would enable the ease of justice. So in that kind of a context, will third-party funding help in promoting arbitration as a means of resolving disputes in India? What is your take on that?
Thank you, Shweta. I think the answer to that is definitely a yes. I mean, I'll just take a couple of data points just to understand why your question, why am I saying it definitely yes. So India's plans for infrastructure is $1.4 trillion in the next 5 years. We are going to become the third largest construction industry by 2025. Now, this is going to raise a lot of arbitration cases, and trust me, the infra companies are always starved with cash because they need huge funds because the sector is such. So the question really is, with this kind of arbitration cases which are likely to come up, let's forget arbitration cases, disputes which are going to arise, where are they going to be resolved? I mean, if you ask this question to yourself, you will say, of course, arbitration. Now, the next question is, how are you going to resolve these arbitration disputes? Because most of these companies, the reason is, I'm saying this because we are all discussing third-party funding. But let me answer the first question, is why this is going to help and promote arbitration. So what happens is, first is it improves access to justice. When there is a third-party funding, you will immediately cases. I mean, probably many of us would have experienced. Definitely, I have experienced where companies have given up cases because they don't find it affordable to pursue them. Secondly, most of them will sometimes come to you and ask for a success fee, which is not permitted by the Bar Council for us to take success fee. So first thing what it would do is improve access to justice. Second is it mitigates financial risk. How is that? A substantial amount of time is spent and resources are spent, and there is no guaranteed outcome. So typically when a third-party funding happens, when a third-party funding happens, it's a non-recourse kind of funding. So therefore, the risk reduces for the company. So today, an arbitration, if it's a large arbitration, the lawyer's fees can run into millions of dollars. So these millions of dollars becomes a large amount of money on the balance sheet of the company. Now, with a third-party funding, the next thing, what happens is that it mitigates the risk. And in third-party funding, what we've seen happen around the world is that there is a certain test and filter which takes place, whether these cases are meritorious enough to be funded or not. So there is a test which also happens, which improves the kind of matters which go into arbitration. Then there is, of course, what provides is a faster resolution, because these third-party funders have a kind of a supervisory role all the time. They ensure an efficiency which comes into this ADR process. Then, of course, a lot of these funds are answerable to their investors, and these investors want to ensure that you are funding companies and you're following those processes in arbitration where there is certain ethics, code of ethics which are always maintained. So when the third party funder steps in, there is a certain amount of quality of arbitration and code of ethics which are followed, which I think provides substantial benefit to the ADR process. And of course, as the ADR process arbitration is chosen, you naturally will reduce the reliance on the Indian courts, and that would reduce the burden of the courts in India and provide more efficiency in the arbitration. So I'll pause here for a minute, because there are I could speak a little bit more on that.
Sure. No, thank you so much. And one thing that has stuck to me is that you mentioned that third-party funders probably are going to have a supervisory role. Once they are going to have a supervisory role, and this is something on which there was an observation made in the Tomorrow Sales Judgment, and I'm coming to you, Ajay, on this, where it held that a funder could be held liable for adverse cost, could not be held liable for adverse cost where it was not a party to the arbitration agreement or the arbitral proceedings. In this kind of an observation which was given by the Honorable Court, do you think that a funder should be implicated in execution proceedings when the funder is not a part of the arbitration agreement?
So I think this is a very interesting aspect. And just to apprise everyone, if you are aware or unaware, now this SLP has against the High Court order has just been filed last week. So we'll soon know the outcome, the view of the apex court. But it's a very interesting thing, because historically, people have been sponsoring litigation. We have seen it in courts for years and years, especially the ones on real estate, every property issues. But now when we talk about impediment in, say, execution, in the absence of law on this point, either we go back to contracts or we have some law in place to fasten liability on funders. So the way it is now, in my own view, having seen the orders of the High Court, I don't think you can implead a third-party funder in an execution, especially in a case where they are not a party to the arbitration. And here, very interestingly, the arguments which were made in court, which appeared to all of us to be very basic, that how can you implead somebody who's not a party to the arbitration agreement? So obviously you've not invoked the arbitration against that entity. The party is not a party to the entire issue, arbitration. And then in execution, the answer is that costs were awarded in favor of the other party. And since the funder has funded the claimant side of the case, they would have gained out of it. Hence, it's an investment for them. Therefore, for securing cost, I want to implead them. So it's a very difficult thread to follow, really. But it may have appealed to the High Court judge who heard the matter singly, that yes, because if a person has a vested interest, apparently, in the arbitration or the claim or the awarding of the claimant's claim at the end of it, then he can't just simply say, I will be only party to the reward, but not the risk of it. So that may have appealed. But then again, interestingly, in law, our appeal court said something different. They went on the very simple concept that if you are not a party, you were never impleaded as one, then you can't be impleaded in execution. Right. But the law on that, luckily, will now be resolved once the SLP is heard, and we see how the courts interpret this in the absence of any legislation. So
sure.
That's my view on that, Shweta.
Sure. Thank you. Now coming to you, Naresh, because you have heard all the interesting perspectives with respect to third-party funding. In fact, in one of the judgments, the Kerala High Court had observed that a Champertus agreement is illegal only when the object of the agreement is illegal or if the conditions of the agreement are violative of the principles of equity, justice, and law. So, or good conscience, or the agreement discloses an unconscionable bargain. So, whether a transaction is unconscionable or not, it will of course depend upon the facts of each of the case. So, according to you, what is the proportion of the amount which is paid to the funder or investor from the recovered amount would be deemed to be so excessive that the arrangement is categorized as extortionate and unconscionable in case of a favorable outcome?
Thank you, Shweta. To begin with, first thing that we must recognize is that unlike, UK where Champati was, looked at very strictly, in India, Champati's agreement in that sense, and that's exactly what the Kerala High Court says, that it's not illegal or void. The question truly is that what are the iniquities that one can find, what are the iniquities that one can get out of a contract to, make it a unconscionable bargain. And those terms are the terms that, the courts would usually look for. There is no one size fits all answer. One cannot say that if the proportion is 50-50, then it is an unconscionable bargain. In fact, on the contrary, there has been a decision as far back as in the 1960s, late 1960s, where exactly a 50-50 bargain, the court held that, in a situation of this kind where if the funder has actually brought in money and he is staking a claim and has also, is also taking some kind of a punt on it. I mean, the punt is a very loose, comment to make for something of this kind, because if you are truly taking a punt or if you're taking a gamble, then the courts are going to look at it very strictly. When I use the word punt and a gamble, here is a third-party funder who's actually put his money in. He does not know, what the outcome truly will be. He's done his due diligence, but as many due diligences as we do of a matter, we all understand that, the best matters you go on to lose, and the worst argument may win you the worst matter. It's always a chance that one takes in court. So what truly happens is that, where someone has brought in money, has taken that kind of a punt that I'm talking about on a matter, the courts have usually held that, so far as he's not a rabble-rouser, so far as he's not someone who's going to actually proliferate litigation, he's not there to do that. So, take example of a PIL. A PIL is, what is a PIL? It is one kind of third-party litigation funding. But we all, and we all understand what happens in a PIL. Because there are numerous PILs which are actually private interest litigation rather than a public interest litigation. And these are the kinds of things that, courts are looking for. And I remember way back when our CJI was in the Bombay High Court, one matter did come up before him as a PIL. It was against one of the cricketing bodies, not the BCCI, but, one of the other cricketing bodies. And the question, raised by him in open court was that, is this a PIL? Is this? And he went after the person who had actually signed the PIL to say that, who are you funded by? From where have you obtained the fund? What is your interest in the petition of this kind? So that is what the courts are truly looking for. In situations where, let's say, you could have a situation where you've got what you asked for, and then you are levying an interest on that money. Would it be an unconscionable bargain? The courts have held that that's an unconscionable bargain because you got what you had contracted for, but now you are levying an interest on that amount as well, and you're trying to gain something more out of it. It's an unconscionable bargain. In a case where, I remember a matter in the Bombay High Court again where it was an issue concerning a group of farmers. 25% is what was to be taken away by the so-called funder. Obviously, it is not the third-party litigation funding that you and I understand. It's more of, in the mofusils, when you go, you have the so-called thekedars as who we understand. They were the ones who were funding it. Right. The 25% what was being taken away in a situation of this kind, the court had held that it is unconscionable bargain, and that, such is a situation where we have to step in, our conscience is challenged or woken, and therefore, we will hold that this is not something that is right. So you started off by saying that it will depend upon facts of each case, and exactly that is what happens. So Indian courts are not going to, one thing is clear, that third-party litigation funding in India is something which is acceptable. It has been accepted, like you rightly mentioned, since 1876 and even before that. But courts have been very careful. They have always kept an eagle's eye on what sort of agreement is being entered into, who are the counterparties to the agreement, what extent and what proportion of money is being sought to be taken away, and for what reason is that money being taken away. So these are the things that courts will usually ask when deciding upon what proportion of the money truly represents or does not represent a conscionable or an unconscionable bargain.
So thank you for giving a completely different dimension to this third-party funding as a concept. I think that's an interesting, take on that. Now, all of you as the industry leaders for the legal industry have a sense of accepting the fact that third-party funding definitely is going to help litigation or arbitration, in that sense that it will take care of a lot of issues. Even after all of this and all of the positive attributes that I did hear from Nusrat and from Naresh, and also if we look at the other jurisdictions, and I'm coming to you, Neeti, with this question, because if we look at Hong Kong, if we look at ICC for that matter in 2021 has accepted as third-party funding as a in their rules. And also, for that matter, SIAC has, introduced it in their rules since 2018. So with these institutions already accepting this third-party funding as a concept, what do you think are the trends and approaches in institutional arbitration that have taken towards third-party funding? And could institutions frame rules for third-party funding with no underlying legislation in India? Because that, I think, is the general, sense that I get, is that because there is no legislation in India, and therefore probably third-party funding has not been able to take shape as it should have. So do you think that is probably the right approach?
Thank you so much, Shweta. I'm just trying to see that when should I wear the MCI hat and when should I drop it in answering this question. Let me begin by this, that when Shweta started to talk about it, Naresh spoke about 1960s. We've been having third-party funding. Nobody has said a no to it. Then why is it still a topic? Just because we can do conferences like this and have another session? Or there is something more to it, right? So what are the trends that we are looking at it? When I was doing my research, to be speaking here, and I said that let's just look at least which countries have legislated it. Very interestingly, there are only 3 countries which have come up with a legislation on third-party funding. We all are aware about Hong Kong, we are aware about Singapore, and the third one is Nigeria. And we're wondering that is it really required to have an underlying legislation to it? But then let's look at what about the institutions. Of course, HKIC was probably one of the first ones to have its rules on third-party funding. SIAC has it. As far as we know that CAM CCB has it, CTAC has it. Then you go to Milan Chamber of Commerce, they have it as well, but they don't have an underlying legislation for it. And of course, then in 2021, ICC came up with it, and ICC very clearly said that the duty to disclose third-party funding is on the party. MCI has it, not yet. I need to wear that cap and come and say that we don't have it. But of course, we framed our rules 7 years back. We just completed 7 years a couple of days back. We are revising our rules now. And I'm hoping that when the rules committee is putting all of this together, it's definitely in the mix to see that has the time come for India to have, or at least the institutions in India, to have a third-party funding. Of course, when you'll have the draft rules, they will be out for public consultation. We would love to know your views on that as well, that whether Indian rules should have it or not. What we clearly know is this, that third-party funding is out of the dusty doctrines of champerty and maintenance. They don't exist. Then why an underlining legislation we keep talking about? What I can come up with one thing is that when you talk about this duty to disclose, right, there is a third-party funder involved. A party has a duty under the existing rules that they should disclose it. But what about your funding agreement itself? Do you just disclose the fact that, yes, I have an XYZ funder and just leave it at that? Can then the arbitral tribunal go a step forward and have a disclosure on the funding agreement? And if they go ahead and tell you to disclose a funding agreement, then are you in the breach of your contract with your funder? Because most of the funding agreements provide for a confidentiality provision and say that you can't disclose this funding arrangement. Whether I'll take up 40% of the decretal or the awarded amount, or whether I'll take up the 90% of it, is something between the party and the funder. So to answer your question, Shweta, my personal view, I wouldn't say for the MCIA, my personal view is that having a legislation back up these questions makes the arbitral institution's rules easier. Otherwise, being in the jurisdiction that we are in India, and like Naresh said, you never know what goes to the court and how it is interpreted. These questions may just make the life more difficult. We don't want a situation like emergency arbitration, right? Where it's existed for so long, institutions have it, and then you need it to be tested to see where the courts go on that.
Right, very interesting. And I would want to put this as a question to audience as well. I mean, do you think that there is a legislation required with respect to third-party funding? Or, and if yes, then please raise your hands. So which means there are only a handful, I think about 15 people who are wanting the legislation, and the rest, I assume, do not want the legislation. So that is absolutely possible. But then I would want to understand this from the panelists. Maybe Ajay, you would want to throw some light on whether there should be a legislation, or you think that self-regulation is the best way forward in this regard.
So in my own view, it's a commercial contract. If somebody wants to fund, why call someone a third-party funder and make it larger than life? Take a loan. All of us know if we have to contest, we know the estimate of cost, borrow money. It's a simple loan agreement having an interest. Nobody will have any kind of issue with that at all. So in my view, to make a law out of it and complicate life is not done, but that's just me.
Can I just come in here? Yes, please. I think, Ajay, I understand that you're alluding to the fact that one could just take a loan and, maybe your brother, sister, anybody could just give you money as well and go fight the case. But then in the arbitration circle, aren't we looking at questions of conflict of interest? Right, which always becomes with respect to an arbitrator as well. If you do not know who's funding, what's their trend has been, and then all of a sudden, imagine when you are at a stage of closer to an award, you sprung up with this or this fund, this entire arbitration was funded by so and so, and now I have a problem of arbitrator to be replaced, which is not unheard of, right? So in that sense, to at least have certain set of regulations, to have a framework within which you work, maybe not over-regulate, may just add on to the may probably take away some work from the lawyers not to argue in the courts.
Yeah, so I'll just add to what Neeti has mentioned. Our experience as lawyers would be that wherever there exists no legislation, that it's very dangerous in a country like India. In India there has to be clearly a legislation where if you don't prescribe, then you are getting into deep waters, and that is dangerous. So I would agree with Neeti. I know
Naresh,
what you mean by that, but
not respond to this.
No. No, so I agree with what Neeti says. I think there are two parts to this. To my mind, I do agree with what Ajay, the manner in which Ajay has put it. Yes, it's a contract, and give a free flow to the contract. But nonetheless, there has to be regulation in and around the how the contracting is to be done. What are the confidentiality measures? How much of confidentiality or otherwise. And like Neeti mentioned, how would the courts otherwise understand whether it's an unconscionable bargain or not without possibly going into the contract? So if it is, and we have this in now arbitration that everything about arbitration is going to be confidential, but if there are requirements of law, then that confidentiality will have to be given up, and you will have to then bring in those circumstances the confidential documents as well. And it could very well be that you bring it only before courts, and the courts will in that sense, while we have heard this from the Supreme Court that documents in envelope is not the way forward, but in situations of this kind, you may need the documents in the envelope. So therefore, how much of regulation is also going to be the key. In India, we have no half measure for things, and that's the problem. When we regulate, the pendulum swings from one way to the other. Either we will say that, when we regulate everything, we will look into everything per se, which truly does never work, because in that situation, everything will fall apart. Or it's the other way around, where we let people self-regulate. And I'll give you the best example in that is, I remember the point in time when I used to do a lot of tax matters, and that was when the regulation was by the authorities. And for everything, you could raise a point to say that, oh, but you, the authority was there and you looked at my assessment, and therefore, how are you now raising an issue with what I have done? And today the pendulum is swung exactly the other way around. You look at your GST, you look at income tax, they now talk about, self-assessment. And it's a problem. The moment you come under self-assessment regime, everything that you do, even if the regulator has had a look at it, you are in trouble, because you are the one who was asked to make the declaration. You are the one who has actually gone ahead and made the declaration. How much you've disclosed, how much you've not disclosed, everything becomes a problem. So there are no half measures, as I said, in India, and that's the reason for anything and everything that we do. The regulation that we are talking about will have to be a nuanced regulation, and it will have to be in simple English. Otherwise in India, again, all that we lawyers do is fight on, what is the interpretation of a provision.
You are taking away our jobs. Badriji, you would want to say something?
I can just say
related.
something in
Yep.
rejoinder,
Yep.
because see, already in India we have so many laws,
Absolutely.
then we have regulators,
Yeah.
and one classic example which I always share is our own Arbitration Act. Earlier we had a suit, appeal, Supreme Court. Then comes in arbitration. You have the award, objections, appeal, then Supreme Court. Thanks to our amendments, now we are in a zone where things are time-bound, apparently. We on our own add layers after layers, which is good for lawyers, so no complaints, have a law, no problem. But my only view is, each time there's a new law, like you just observed, again that goes into court for interpretation. So we have the draftsmen of the laws, whatever they feel best, they add it, and then we have case after case, how to interpret that, which goes on for years. So also to add one example, which I always also share, ours is one of the great places where we have a law, please wear a helmet, or you'll be penalized, because if you don't wear a helmet, your skull will crack.
Yep.
So, that's the kind of laws we have. So in
Completely
my
agree.
rejoinder, I don't need a law on this.
No, absolutely. And I'm in agreement with you, because I personally also feel that we are over-regulated in that sense. We have too many legislations for too many things. And I don't know how much of it actually comes into play, when it comes to effective implementation of it. And more so because in the Arbitration Act, where we've seen multiple judgments after judgment that Abha was actually talking about, that only shows that, we have been over-regulated in those sections and provisions, and then also we have no light in the day. So I personally am also, of the same view. Badriji, now coming back to you, because I think it is important to understand from the industry perspective, what are the impediments of the companies which have been negotiating with the funders on the third-party funding, and where lies the obstacles in terms of bucketing the disputes that are to be offered to the third-party funders?
I think this is a very practical experience which you asked about it. Usually when we go for just look at, I'll cite some numbers so that you can also do the kind of brainstorming, whether the deal is a good deal or a bad deal as such. I mean, no deal can be a good deal unless and until it comes in your favor. But otherwise, the numbers are that there are about 150 to 200 kind of litigations in various stages, right from notice initiation to that of appeal landing in the Supreme Court. It's a factual data. There are about 200 litigations or the potential litigative situations. And the amount which is at stake is about 5,000 crores. So if I win all the litigations, I would get about 5,000 crores. But if I don't win all, that's a different call. And the probability is that 50-50, that 2,500 crore is something one can be reasonably sure about it, plus interest on it. So obviously it would work out around 3,500 crores. These are the numbers I'm just giving it to you. So against a potential 3,500 crores, when you go for the negotiation for the third-party funding, they would try to give you as little as 1,000 crores. Is there any meaning in it? Look at the numbers. Look at the way in which I've been skewed. So it's about 1,000 crores vis-a-vis a potential 3,500 crores with interest element in it. But ultimately, the deal is struck for about 1,750 crores. Is it a good deal or a bad deal? I leave it to your good selves and the kind of a wisdom. You think about it. a potential 5,500 crores to 1,750 crores that has been given, with a caveat that certain things will be exempted and certain things will be given back. Whatever it be, these are the kind of a numbers against which we are swimming. So in this context, at least there is somebody who has come in a limited way to one or two companies out of hundreds of companies which are now in queue for the third-party funding. At least 1-2 companies could do it, and some individuals, some firms are doing it. But other than that, today the matter is not open. So what I would simply look at it is that from the government facilitation is that they can as well give a notification. I'm not looking at a situation of amending a law or proclaiming a law or anything as such. They can give a notification that for all the matters related to litigation and this thing, it's a permitted way. Something like a notification can be given, or a directive can be given, or a kind of a direction can be given by the government. That's something which we industry, we look at it from the government so that it would facilitate the process. Now, when it comes to kind of negotiating and bucketing these things, the claims, what we try to do is that, I'm speaking from the industry, what we try to do is that where we are potentially not winning are the ones which we would like to bucket. But from the third party funding side, what we are potentially winning is the ones which you would like to take, and what we are not winning is what they would not like to take. So that be the case, there is a question of mix and match we need to play around with. Either you go with 100% or you go with some pick and choose kind of a modalities between these buckets of litigations. So definitely when we do it, we knew for sure that those which are in the nascent stage of litigation is something which will cut it out, and which are in a mature phase, either at the High Court level or the Supreme Court level or the final arbitral award part of it, that is something which we would like to put it in. So that there is a value optimization in the efforts of the company to realize the money. Now there is one point, borrowing a loan versus structuring a kind, there is a structuring which need to happen. How does it happen? Does it happen directly? Because today with the kind of a skepticism we are in, that the third party funder cannot be disclosed by virtue of the disclosure agreement which is confidential to itself. We need to come into some kind of an arrangement, because there is no clarity on there is no clarity on the surface. We need to come into some kind of an arrangement whereby the best way is to create a kind of an SPV. Into SPV, all these things are taken, and that's one structure which is recommended. That's how we go about it. So coming to the bucketing and concluding my short take on this is that it's a very difficult thing to negotiate TPA. Don't think that the TPA comes cost-free and TPA comes to your advantage. TPA comes with many, many caveats. And these caveats are built by not by the TPA people, but the law firms which are advising the TPAs. Right. That's another aspect I wanted to put it out. No, so I would request the earnest legal firms over here, as well as the members on the panel, to see that this is somehow facilitated and the positive outlook is given for the TPA to become a success. So more than the government legislation, it's the legal firms and it is the courts. They need to take a collectively positive look to the TPA to make it successful and meaningful.
So one last question, and that goes for all the panelists, because I think we are running out of time. We only have 2 minutes left. Ajay, this is first to you, and then probably Nusrat could add on this. Would TPF have the capability of turning arbitration entirely into an investment business? So that is the question for you, and Nusrat, for you, it would be whether it is going to be possible, in the sense that there are a lot of third-party funders outside of India. So whether it is possible from the FEMA perspective to be able to do this kind of a transaction. So these are the two questions for Ajay and Nusrat. And Naresh, you can add on wherever you think that you would want to respond to.
Yeah, so interestingly, we all know that the entities which are doing all this are either investment banks or hedge funds or corporates. So I don't see it as a different thing than any other investment. People can assess commercially whether it's worth investing in this venture, project, or anything. The other aspect is that in a way, so where I'm in favor of this exercise is that a person investing will surely get a case evaluated, and there and then will give the right picture to the person seeking funding, whether you have a case at all. And that will maybe inspire them not to litigate as much as we do in India. My only thing was that on the other aspect, we have the litigation in courts, we have arbitration, we have onshore, offshore, whether this will work in the larger scheme, but in my view, it is a pure investment, it's pure commercial contract.
Nusrat?
Yeah, so I agree with you that this is a commercial contract. So most of the funding firms are international firms. So when if there is any funding that is to take place for a domestic arbitration, I'm just talking about arbitration since we are talking about ADR, it is not possible under FEMA. Because FEMA, there are several things which kind of makes it almost impossible under FEMA to fund a domestic arbitration, because there is no, neither is this put in a certain sectoral, there is no sector in which it will fall into, nor does the definition of it falls under definition of investment, because investment can only happen in securities. Neither can it be a loan, because then the ECB regulations come in. So at presently, I don't see, there is a lot of interest. I must add, there is a substantial interest. Anand and I think during COVID must have met, several, we did a lot of joint presentations to a lot of companies. And I think there is a lot of, there is a lot of challenge, many challenges, but one of the big challenges is how are they going to bring the money in and how are they going to take it out? FEMA doesn't define it. At the moment, there is nothing. So really what we need to do is, push, there is quite clearly we have to talk to either the Commerce Ministry or the Finance Ministry or the RBI. I think it may be the RBI, because if it is closest to the financial services, then RBI will regulate it. That means that, RBI has to come out with a policy. Otherwise, it's just a contract. It's a, third-party funding. There is just an agreement. It's known as a TPF agreement.
So
that's the difficulty.
I'll just take one moment on this.
Sure.
I think, and I'll take the point that Nusrat made, and I'll take it forward. Look at it from a slightly different perspective. Under Foreign Exchange Management Act, under that act, there are just two possibilities. Either it's a capital account transaction or a current account transaction. And depending upon the sort of agreement that you enter into, it will fall under either. So, if it's a debt, and I'm just taking a situation of a debt, if you take a debt, it is clearly a capital account transaction, and also from a tax perspective, it will have a hit. Because if, so the treatment that you actually give to your agreement, basis that, whether it's a capital account transaction or a current account transaction, and therefore, whether it's permitted or prohibited, because if it's a capital account transaction, it's prohibited. Right. And on the other hand, a current account transaction would be permitted unless prohibited. So how you craft your agreement will tell you where you will fall. Two, from a tax perspective as well. In India, nothing is simple, as I said. You look at it from a tax perspective, there are, two entities that you're looking at. One is the entity which is being funded. The other is the entity which is actually going to take the money away. If it's a capital receipt, then, what is the implication of tax for the person who's actually getting the money in? And from that perspective as well, your FEMA angle may change, because it will, if it is something which you have, which a domestic party has brought in, kept with him, it does not affect his asset or liability, it will not fall within the capital account transaction. But if it does, from a tax perspective, FEMA also will, kick in, and there will be a problem from a FEMA perspective as well. So a whole lot of things need to be thought through. Maybe the master circular, like you rightly put it, you can have the master circular, RBI can come up with a clear guideline, can tell us, which way to look at. But even so, to my mind, the crafting of the agreement will become extremely important, both from FEMA as well as from tax perspective.
Thank you. Thank you so much. And with this, I bring an end to this session. It's a very interesting session. I definitely learned a lot from the panelists. I'm sure all of you would also have done, and I'm sure there would be a lot of questions in your mind, which I would request you to take offline, because we are running short of time. We have already, exhausted all our time that we had. Thank you so much for being so patient, and thank you to the panelists for such interesting answers. Thank you.